So thank you everyone again for joining us today. First, we'll kind of introduce ourselves, a few housekeeping items, and then we'll jump into the presentation. To start with myself, Matt Rupert. I'm an advisor on the Palomar Wealth team. My background is a little varied. This is kind of a career move. I worked in corporate world for 10 years, accounting degree and taxes by trade. And then 5 years ago, stepped into this role as an advisor. Kelly and I do work on estate planning as part of our roles here with the team, but it's a lot of different elements that we work on as advisors.
And I am Kelly Holloway, another advisor on the Palomar Wealth team, and happy to be here. I was a career changer as well. And so in the last 5 years have become an advisor, went through a series of education to achieve my certified financial planner designation. So get to call myself that fancy CFP term, and really just love to help people learn. When it comes to education and finances, I think that's the best thing we could do as advisors is help walk alongside our clients. And so our intent today is to provide information to help you better prepare for your estate planning. And if it's something that you haven't done before, to get started with that, to hopefully inspire you to take action.
And so we do, obviously, we should state at the beginning that we're not providing any legal advice. I know that's a very common, cover your butt type disclaimer, but we aren't providing any legal advice. And as advisors, that is something that we have to be mindful of, is not giving unauthorized legal advice. But more broadly, why is everyone here today, or why many people probably joined, is that this is probably an important topic that you've thought about, talked about it for you, your household, your extended family even. And our goal today is going to be somewhat higher level. We want to talk about understanding the different pathways that you can go down for planning. Now, we won't cover, very specific types of trusts because there are a lot of different varieties. So this is going to be more basic, but hopefully still very informative for everyone as they try to learn. Kelly already mentioned we're recording this so that we can share that with our clients outside of today's live meeting. Our plan is to speak around 40 minutes, so that will give us a decent amount of time for Q&A. We have a couple that were submitted already. We'll definitely address those, but we'll try to open that up for everyone if they have anything that they want to share during the call. And then Kelly, did you want to?
I did. This I think came from just our last week's church service. I don't know if it was everyone's same liturgy, but one of the items was Psalm 90, chapter 12, teach us to number our days so that we may gain a heart of wisdom. And I think when it comes to estate planning, it can be a scary conversation. It can be difficult emotionally to think about what happens when I pass away, what happens to my family, my loved ones. How can I prepare myself and prepare them for the best outcome possible? So that's our goal today.
All right, so we'll get started with our slides.
Want it to move forward. There we go.
And we are going to have a little participation here as well. As I start this off, we have a poll that's going to show up on your screen. Should be there now. But first, talking to this opening slide, this is just a factoid that I wanted to throw out there. And this is really a call to action. You look at the statistics on estate planning in America, almost 2/3 of Americans say having a will specifically is important, yet less than a third actually have one. And we're not intending to want to scare anyone with this meeting, but really some of these next slides, there are some statistical based things, is to really look at what are some of the behaviors and reasons that people either delay or procrastinate doing it, some of the age ranges, what are some of the just data points there, if that gives us any information on how we're behaving ourselves towards estate planning, how others are looking at that as well. And so we did get everyone. Thank you for answering that poll. Looks like we're about 70% have an estate document. Oh, it just changed on me. Sorry, another person came in. 63% of the attendees do have the current documents. 33% do not. So I think we're a little bit ahead of the curve, but still work that we can be talking about. Okay. On the next slide is just some more statistics on what age groups we've seen have, a certain level of having their wills done. I think maybe not unexpectedly, we see the 55 plus range as the highest percentage. Why the why is not quite there. I think a lot of it's probably, on the older side of life, where you're on life expectancy at that stage. Are things more, is there more risk or chance that something could happen to you or someone in your family? But interesting, you see the different years here on the chart. There was actually an uptick in the millennial, the lower age ranges during COVID. I don't know if that was a sense of, facing someone's own mortality was a little more in your face at that point. So it was interesting to see that as well. But another thing that brings up is looking at, the percentage for millennials, Gen Z, what is that question? We've heard that before. Well, why do I need it? I don't have anything. The millennials might say like, well, I haven't accumulated much when it comes to, financial or physical assets. Well, with that question, one of our answers would be, well, it's not just about financial. When you talk about estate planning in totality, this is providing direction for your family. It's also you giving instructions. If you were to become incapacitated, someone's going to have to step in and make decisions on your behalf. So it's not purely about me having X number of dollars or I have these particular assets. It's a playbook for what's going to happen when you're gone, or even when you're not gone, but you can't do things for yourself. So again, into that kind of the behavioral side of us thinking about why have we or have we not gotten our estate planning done, and here's some kind of percentages. And again, I think not surprisingly, there at the top with a pretty big margin is, someone has a health concern or a medical diagnosis comes about that inspires them, okay, to go get estate planning done, death of a loved one, family expansion. So it's having those personal or family experiences is what's triggering them to do it. I mean, at the bottom, but I guess somewhat disappointing that there's 23% said nothing would motivate them to get their will done. But again, reflecting on what have I been doing or not doing, what's happening in my family, what are my behaviors that could be different to lead me towards getting an important part of my, family planning complete. And the last, slide here for statistical purposes, what are some reasons Americans are giving for not being engaged in estate planning? There we are, procrastination, number one. And I heard this, and I'm copying this kind of idea or quote is, be a finisher and not a starter. There's a lot of people that will, and it's not just with estate planning, right? But in this regard, if it's something you truly believe is meaningful and important, don't just start it, make sure you do get to the finish line. Hopefully this education is a big boost to getting that started and getting you to the finish line. But again, many reasons that we can come up with why we're not doing it. But hopefully this is something that can be that catalyst for change.
Now that we understand the numbers a little bit better, I think it is the next step to move on to what actually goes into an estate plan. So starting off with the why, creating an estate plan is really designed to provide you an effective and efficient transfer of your assets and also make sure things proceed according to your wishes. So whatever those may be. So there's a level of control that we're impacting, either you're still living but not able to make decisions, or even after you're no longer living, that you're able to still affect some control over how things proceed, and also to make sure that you are making those decisions versus someone else being given that power, such as in a court-based process where someone else has to decide, what's the right thing for your remaining assets and possibly your family. Privacy. There is an aspect of privacy when you go through a probate process, everything becomes public record. As we'll talk about in a little bit, there are some ways to protect from that if that is a concern. So even just having a beneficiary listed on some type of a contract or investment will avoid probate. It goes directly to your beneficiary, no public record needed, but also a trust is another alternative. And an example of that would have been if you know the movie, The Black Panther, Chadwick Boseman was the main actor, and he passed away at a very early age from I think a cancer. And he had no will. Everything became public record, and that can be, you know, repeated. You've seen that many times, and we'll get into some of those examples later. But peace of mind. There's also a quality of knowing what you've created is already complete, having the sense of confidence that what you've done is going to benefit your family and not have to be concerned about that anymore. So going into an estate plan, like Matt said earlier, it's not just that will, which is a document. It's also all of these big questions that we're answering. So who is going to receive those assets? Who are those beneficiaries? How will they receive those assets? You know, and what method is it going to be distributed? Are there any sort of gateways or you know, milestones they have to pass in order to receive assets? Who would make those financial decisions for you? And or healthcare decisions for you if you're no longer able to do so. And then if you have any minor children or dependents, you know, in a special needs type situation, or even caring for elderly parents, who takes care of that after you've passed on? And so these are the most important questions we are trying to answer when we're creating, as individuals, a estate plan. So those documents that we most likely will see in an estate plan are going to be a will, a trust, a medical directive, and then a power of attorney for finances. So going into more detail on each of those, the will itself is that legal document that states what is going to happen when you pass away. And the will name an executor, a person who's been charged with a fiduciary responsibility to take care of your wishes. And that person will go through multiple steps, and we'll show you that in a little bit, about how to proceed with your wishes. You may also have a trust. This could be in conjunction with your will, and the trust could be the legal entity, the legal document that holds your assets for another person or persons, so the beneficiaries. A trustee is a person that is in charge of managing that trust, and they also have a fiduciary responsibility, meaning they're legally and ethically bound to do the right thing for the beneficiaries, and put their needs last. And often you'll find that an executor or a trustee may even be the same person within a family. There's some other documents that go along with the trust, such as a certification of the trust. This is a short statement to say this exists. General transfer, so moving things into the trust if it's not named directly as a beneficiary. Occasionally, people will name a trust as the owner of a piece of property, so you may have a property agreement. But then we move into financial and medical powers of attorney. So this is not so much for when you've passed away. This is exactly for when you are living but no longer able to make decisions on your behalf. So a financial power of attorney may be very broad and say, I grant this person power from day one, or it may be springing upon your incapacitation. You'll find that there can be different specifics where people may want to name a financial power of attorney for even just a single transaction, such as I'm out of the country and I need to complete my real estate sale. So powers of attorney are more than just an estate plan, but in this sense, it's really becoming part of what happens if I'm incapacitated. The medical power of attorney, that would be someone who's able to make those medical decisions on your behalf. And you can also provide more instruction with that. So healthcare wishes are greatly appreciated to be included with a medical power of attorney. And those statements of wishes can help people better understand, you know, what would my, you know, let's say it's your spouse or a family member like to have happen in these situations? Would they like to receive a care, you know, that extends life as long as possible, or are they looking for quality of life? And so at a certain point, allowing the healthcare power of attorney or the attending physician to help make better decisions on, is this quality of life what they would have wanted? And then a HIPAA release to allow people to have access to your records, because as we've all known, we have to sign that every year when we go to the doctor. Do you want your copy of the HIPAA release? So making sure that everything's above board and you have everything you need to be able to effectively be that healthcare power of attorney.
All right, so I wanted to talk more about some differences, pros and cons of going down a will-based approach or a trust-based approach. So a will is going to go through the probate process. So if you have assets that aren't titled to anyone and you have a will, That's what's going to control how those assets are passed on after you've passed away. And that's going through the probate process. Kelly alluded earlier that, public record, since that is something that gets filed with the court records, technically someone could go down to the courthouse and get information about that. One of the big things here is taking effect at death versus taking effect before death. With a will, really it's not doing anything till you passed away. And on certain trusts, and the trusts that we deal with in our practice are living trusts that exist as soon as you create them. And so there's things that you can have take effect now after you create that, such as moving real estate into the trust or opening investment accounts that are owned by the trust rather than being in an individual name. Avoiding probate, I would say, is probably one of the big pros versus wills when it comes to comparing them and the privacy. Both of them are about control. I know we've mentioned that before, but that's probably a good word to sum up what you're trying to achieve, no matter which path you're going down, is control. The difference is, though, if you want to list out, I think Kelly's word milestone is a good term to use. If you want to do more than just like, I want, Bobby and Susie to get 50-50 shares, if you want to have stipulations, you probably are going to have to go down a trust route. A will is really just going to let you list out that beneficiary split. You don't really get to get any more specific than that. On the trust side, you have more flexibility to create those type of situations. So not necessarily saying that one has to be superior than the other, but really thinking about what needs you want to accomplish in your estate plan. And another thing we wanted to talk about is the power of attorney role and executor. I have many times heard, either through clients or just other people, that I definitely see that there's a misinterpretation that a power of attorney and executor are the same thing, and they are not the same thing. A power of attorney, that power is done and ceases to exist once that person passes away. So if you were the power of attorney on a spouse or family member, once they passed away, that power is gone. You're no longer able to make any, financial decisions, healthcare-based decisions on them, because that power has now stopped. The executor is really that role, or in the case of a trust, a successor trustee who's going to step in and has powers then after death. And the probate court, is the one that's going to confirm and say, yes, this person can act as the executor, assuming that you named them in a will. So there's also some timing components when it talks about power of attorney. You see a couple listed there: springing versus durable. That gets into, do you want that power to spring to life in a triggering event? Many times people will, not grant that power until, oh, I bumped my head, I'm incapacitated, or I'm in a coma because of medical issues. You can have it be immediate. Oftentimes spouses will do that. Or like Kelly said, it doesn't have to be estate planning based. You could give a limited power of attorney to a real estate agent, if you needed them to sign on closing documents or things like that. So definitely some differences there, and I have seen some or heard of some misunderstanding of those terms.
And I would also add about the springing is that incapacitation has to be determined by the attending physician. And so in certain situations that may slow down a power of attorney to, be able to act. And so depending on your level of trust with the people you name as power of attorney, a durable may be more straightforward for a spousal situation or someone that you're very confident will always have your best interests in mind. Whereas a springing, you would really want to limit their power potentially until you're actually in an incapacitated situation determined by a doctor. And this is something that we have come across through some Thrivent materials that I really appreciated being able to see, because I believe that the term executor gets bandied around and people may not always understand or appreciate all that goes into what does it take to be an executor for someone. And so if you're on a computer screen, you could probably see this well, and if you're on a phone, it may not come through quite as much, because it is a long list and it can stretch into 1 year plus, 2 years plus sometimes, and longer, depending on how complex the situation may be. And so as the executor, you have the legal responsibility to process all of the instructions in the will. And that means, finding out what assets does this person have, who are the correct people, determine that those are the people. I think Matt put up a poll here. Have you ever served as an executor? So please take that, because you will know personally how much work it is. And so when you're naming someone as executor, be aware that you're asking for a great responsibility and time commitment, and they can compensate themselves. You can put that in the will. Many people choose not to, because it's often family members and they don't want to take away from the estate. And if things stretch out further past the year of death, you may even end up having to file a trust tax return, and a lot of other complex situations. And people may contest the will, and there's a lot that you might have to work through. So this long list could go on and on. This is just kind of a general overview, but it entails many, many things. And it looks like from the poll, the executor poll, about 67% of people have served as an executor. So you could appreciate this, and 33% have not yet. So just be aware when you're asking someone to serve as your executor, this is a large responsibility. Get this to move on. Come on, there it goes. Oh, yeah, there it is. All right, Matt.
All right, so we wanted to circle back to this because I think this is a very important concept to understand. I call this the order of operations, and this is so people can understand how the order of assets transferring on death would take place. And this is whether some of this applies whether you have an estate plan or not. Some of these happen that way. So at the highest level is listing out beneficiaries. So if you have financial accounts, whether that's IRAs, joint accounts, individual accounts, life insurance contracts, if you list directly beneficiaries on those, then it's going to transfer them, assuming those people are still surviving you when you pass away. There are some things you can do. We have those two Latin terms, per stirpes, per capita, and then lapse. You can do some kind of customization to help with that. But if you list out the beneficiaries, that's who it's going to go to. So even if you didn't have a will, if you've listed out beneficiaries, it's going to go to them. So you have to keep in mind that they are getting those free and clear. There's no strings attached. That might be okay, right? If you are comfortable with those beneficiaries, I'm getting it without any caveats, but something to keep in mind. Now, those Latin terms basically represent by the branch or by the head. Oftentimes, people will pick that per stirpes because what it will do is, if you've listed a beneficiary and put that Latin term per stirpes next to it, if your beneficiary happens to die before you do, then you later die, the share that they were going to get would pass down one level on the family tree. So that's why it's called by branch. Or there's the per capita. I don't see that one as often, but is an option where that transfers by the number of heads. So if you had, 3 children, one passes away, and that passed away child had 2, so you have 2 grandkids, the whole estate's not going to get split by 5 or 4 because you had 2 children, 2 grandchildren. So by the number of heads. Lapse just simply means it's going to go back in the bucket for the remaining beneficiaries. But order of operations is critical to understand that. And definitely make sure you're going back to any account you can think of. We have an example that came out in one of our newsletters recently. This guy worked at a company, started there back in the 80s. At the time, he was dating someone, put this girlfriend as beneficiary. Years went by, girlfriend's not even in the picture anymore. The company had sent out multiple notices of, you need to verify your beneficiaries. Never did it, passed away. This old girlfriend is now the recipient of this guy's 401k because he didn't check his beneficiaries. So again, control who's going to get your assets. Next down, wills and trusts. So if you have a will, let's say you're looking at a financial account. If you ever see the term, payable to the estate, if you're looking at like your beneficiary section, payable to the estate or payable to the last will and testament, that means that no individual has been named. And if you have a will, your will is going to control what happens to those assets. You could also list a trust. So if you'd created a trust, you can list the trust as a beneficiary. It doesn't have to be a natural person. It can be a non-natural entity. Inside the trust, you probably are having the money go to natural persons, but you can have that trust be kind of the funnel where everything goes through. If, let's say, you have that account that says payable to the estate and you don't have a will, then the states that you live in where that happens, the intestacy, that's that word there, intestacy laws will decide. Many of them are, blood lineage based. So, I mean, it's likely to go to a family, but again, you're not going to be in control because it's the state's laws.
I would say they're just pausing on that intestacy. If you happen to have family members that you are estranged from and your state laws say that it splits equally between remaining family members of whatever level, if you have no children, let's say, and it goes to your estranged sibling, that may not have been your wish, but that is what the state law will direct. Sorry, go ahead, Matt.
No, we're ready for the famous
Oh,
examples.
perfect. Okay, so this is, I think, something we're all familiar with. There are so many examples out in the world where people have died without an estate plan, whether it be a will or a trust or what have you. And some more recent ones, Aretha Franklin, everyone knows, a respected singer, joke for the day. She had two separate handwritten wills, and one was older than the other, and they conflicted. And when she passed away, I think she had 4 properties, and one son was named in one will and another was named in the other. And the court ended up choosing the most recent one. It may or may not have been her wish. And so it's so important that even if you believe your documents are up to date, are they state specific? Have you reviewed them lately? Making sure that they align with today's wishes. I know my husband and I set up a will before children, back probably 2004, and had used that for many years until we got to the point where we really need to update this. And we, by that point, had 4 children. So things change in life, and maybe you have different wishes as time goes on.
So next on that list is Stieg Larsson, maybe not as familiar to everyone. He's a deceased author. His well-known title is The Girl with the Dragon Tattoo. He's from one of the Scandinavian countries. But he died before his books really kind of gained that big following and fame. And he had a partner and writing collaborator that he lived with for like over 30 years. He died without a will. His estate at that point, because time had passed, the books got popular, $20 to $50 million, passed to his estranged father and brother. They were so kind, and that's a joke, that they granted her his apartment and some personal effects, but none of the rights to the literary works that she helped him with, or millions of dollars, that earns in royalties.
And Abraham Lincoln, famously 16th president, but also a lawyer, did not have an estate plan. And I have read that at the time his estate valued over $100,000, and at that time was a large amount. And he, without that, was able to, I believe there was a Supreme Court justice or someone who was legally involved as the executor, was able to help process everything. But I'm sure he wasn't expecting to pass away when he did, and did not have his affairs in order. And so even though he had the legal background and was, very savvy when it came to all of the things he could have done, he never chose to create a will. And so in the end, his surviving sons and wife received his assets, but it took several years. And I think that's the other challenge is that effective transfer of getting to the right person, but efficient and not wasting assets, because I don't think we've mentioned it yet, but probate process can chew up some of your assets, and those numbers vary wildly depending on your estate situation, but it could be, as little as 2%, as much as 10% on average, depending on the state and the situation. So there's a lot to be said for having clear instructions.
Yeah. And last on there is Prince, the musician. He fairly close to, from Minnesota, so not too far away from, what we're dealing with here. And he died from, it was an opioid addiction, but took the court 6 years to get through his estate because there was no will. And there was a lot of situations where supposed, relatives came out of the woodworks and people challenging and wanting a piece of that. These are just unfortunately a few of the many examples.
And then a very, I think, impactful part of this discussion is your family and how do they all relate to each other. I know Matt's has a story, I have a story, and we probably all have a story of a family situation where something caused conflict or stress within a family. The example I had was having seen a family where an aging parent was being cared for in a facility, and one child was joint on everything and able to help, not a power of attorney, but just listed. And then over time, the other siblings were questioning, did you actually do all of these things, in the benefit of the aging parent, or were you taking things for yourself? There was a loss of trust and frustration, breakdown of communication. And so it's almost as a protection for yourself as well, having that family dynamic to leave the legacy of a positive experience rather than a challenge and a frustration going forward.
Now, my personal story is from my grandfather on my dad's side. He was a true American picker. If you ever watched that show, he was a big collector of many different things. And he actually, after his death, the American Picker show actually did come and do an episode at his house. But over the years, my dad and my aunts and uncles, I know my dad especially, tried to get him to put together a will, because he would tell family members that he wanted people to have certain things, whether they were because they were collectible or because as a kid growing up, you showed interest in that, so I thought maybe you'd want it, but he never did it. And I think truly it probably was even overwhelming to him, but that's now left my dad and his siblings in a position where they've got a lot of work to do. They've had at least 6 or 7 rounds of estate sales, so they have an auction company that's come in to try to help get these items to people who would want them. But it's gone, I would say, fairly well. I mean, we have examples when it's not gone well, but it still puts a lot of burden on the family that's left behind on, what did you really want? What did you want to have happen with these things? And so that's tough. And I think another just broad example, and then we have had clients with these are real examples, is farm families. I think there's a lot of times people, the original farmers would like to see the farm stay in the family, but you've had dynamics where maybe only one of the children is still in the farming business, the others have done careers in city folk, and they pass away, and okay, how's this farm going to get split out? And you've got the non-involved family members who didn't farm just kind of see the dollar signs because, oh, I've got all this acreage and it's worth a lot. How does that impact the member that wants to continue to farm it? And honestly, we've seen some pretty bad blood families really getting broken apart because of that not being planned out well. And just a matter of fairness too, I think, is the big thing. Is if you want it to be fair, you kind of have to lay out those rules. So,
and I think sorry, go ahead.
No, go ahead.
The best gift you can give your family, and you're no longer living, but you're able to provide them peace of mind and clarity of these were my actual wishes. And everyone, as much as you can ahead of time, would benefit from knowing that. So not having the, quote unquote movie scene where there's a surprise reading of the will and shock, this is who the beneficiaries are. If you can have these conversations while you're still living, you're providing that smoother pathway for everyone going forward. And that allows them time to grieve, remember you, appreciate who you were and what you did in your life without having to deal also with all of the stress of trying to determine what did they want or how can we make this equal amongst everyone. So probably our last slide here. Where do you go from here? So there are a lot of options when it comes to estate planning. And it's, as Matt said earlier, there's not a thou shalt, this is the right way. It really depends on your situation. So Matt, if you could share some of the pathways people could take.
Yeah, the three images kind of represent kind of the three avenues that we kind of look at it. You've definitely got on the one side of the spectrum, the DIY, do it yourself. There are a litany of resources online that can assist you in creating your own legal documents. And that's another just factoid that maybe some people don't know is there is no legal requirement that an attorney has to be involved. You can create your own documents. I would say not necessarily be cautious, but be well informed if you are going to go into a process doing it yourself and just make sure that it's a good fit for you. We have had clients that we've kind of talked through estate planning. They felt like this is the route to go and they've gone and done it and it's worked out fine. But again, because there are so many resources out there, just make sure that if you're doing that route, that the one you're using is kind of capturing everything that you would like to achieve with that. Next, kind of in the middle would be estate planners. That is the method that we use. So that's a team of planners that basically take what you're wanting to craft into your plan, create those documents for you, and then you get that all back in a method to get it signed, notarized, witnesses, everything that's needed to make a fully and effective enforced estate planning document. On the other end of that spectrum is going to a law firm, working with an attorney. A lot of times I think we see this with more specialized cases now. I think there's a lot more opportunities for the mass market person and family to do on the other end of the spectrum, but specialized cases, we see cases with very specific special needs sometimes have to be, or will go through an attorney's office. But just making it sure that it's fitting everything you need. And so again, where do you go from there? How do you decide on a will or a trust? I always go back to remember that order of operations. If you feel like you're okay with your beneficiary just getting assets free and clear, then you might be okay with making sure everything's titled correctly, that everything's beneficiary, and perhaps you consider a will to capture just your personal property, your home, car, things like that. If you're thinking about, I want more than that, I want specific levels of control, then you might have to go down that trust route if you want to have those type of provisions built in there. Or maybe you're on the, group that's like, you know what, I hear so much about probate, or I dealt with it because I was an executor and I don't want my kids or family to have to do that. Maybe you find value in a trust just because of that aspect of it. So again, it's going to depend on your situation. But hopefully, this has been a lot of information that could help you get to that path of what do I do?
Perfect. I'll say some next steps for today just immediately is get a listing of all of your assets. If it has some sort of beneficiary option, like a bank account, a 401k, IRA, any investment, annuities, something like that, that has a death benefit, double check those beneficiaries and make sure they're accurate and up to date. If you have legal documents, make sure the right people have them. So if you've named someone as power of attorney, make sure they actually own a copy and they know these are the instructions that I've given you and how and when they will be able to help in a situation. There are definitely some more specialized planning higher level trust planning, especially that attorneys will be able to help with. But I think Matt's right. There's a lot of things we can do for ourselves. Or if you're looking for someone to help you with it, the online resources and the estate planners are really fantastic. So some of the questions we received during our registration, we offered an open space for people to type in, anything you'd like us to discuss specifically. So we're going to take a couple minutes to go through those and then just have an open Q&A for anything that's occurred to us during any, questions you might have, comments during the webinar. So the first one was, how much can I gift to my family each year? Or how much can I give to charity? So Matt, start with the family. What's the federal gift limit?
Put on my CPA hat.
Yep.
So the gifting to a family would fall under gift tax provisions in our IRS code. And this is an annual number that actually changes. They peg it to an inflation factor, so it has gone up, not necessarily every year, but over time. And it's currently at $18,000. So, and that doesn't have to be even a family member. You could give 18,000 gift to as many people as you wanted to, but that's the limit for the safe harbor, we'll call it, so that you're not having to file a gift tax return. That can technically be doubled if you're also involving your spouse. So you could do 36,000 if you're using 18 from both you and your spouse. So that's the current 2024 limit, but again, that changes over time. And then if we're speaking about gifting to charity, that could come in a couple different matters. So if it's just purely you're giving away, monetary assets, so cash or investments, that's actually tied to a formula on your tax return. So there is a AGI, adjusted gross income limit. So you can only offset so much of your income in 1 year. You could give beyond that, but you would have to carry over some of that charitable gifting to future tax years if you went over that income limit. So there is not a one number that I can give you for how much you give to charity, because it would all be driven off of your income for that year. Another avenue that does have a more capped number is if you are giving charitably through a retirement account, such as an IRA, you can do what's called a QCD, or a qualified charitable distribution. And that's where you, instead of taking a distribution yourself from an IRA, if you have that money sent directly to a charity, then the benefit there is it doesn't count as income on your taxes. But from a limit, like per year standpoint, that is 100,000 as your limit for the year. That number used to be just always 100,000. It never went up by inflation, but they did just with a tax code change recently. That will now 100 will go up each year with an inflation factor.
Protecting assets was another question, and maybe there's something specific under the hood here of that question, but I think just in general, thinking about protecting assets, I think I've had a lot of conversations with people, especially around long-term care planning, about how do I keep the nursing home basically from spending down all of my assets. If I have a long-term care policy and I exhaust all benefits, or I don't have a long-term care policy, and I have to spend all of my own money first and I can't leave anything behind. There are some very specific estate planners that work with basically how do I move things into a revocable trust so I lose control of those now, but they're named as someone else will become the beneficiary of these. So you do that as a full transfer. You no longer retain control, and 5 years have to pass. And so that is an option. I think typically we don't see that as often. In maybe certain situations, it could be the answer. There are specific annuities that are Medicaid friendly. And so there's a whole area of planning in that, which I was having an email conversation with someone today about that. That may be a future webinar, because I think it qualifies for a longer discussion. So if there was more to that question, protecting assets, let us know during the Q&A. I think Matt can handle the last one. Farm estate planning.
Farm estate planning. Now, I'm not going to say that I'm anywhere near an expert on that, but we have had a lot of clients that are farmers or farmers in their family that we've had discussions with. We also have the benefit that our owner advisor is a farmer himself and his family farms. I've been in some meetings with him where there's definitely some, I'll call them creative ways that people handle their farmland, especially when you think about estate taxes when it comes to farm. Farmland is very, very valuable when you think about the cost per acre and the size that a farm could be, passing on to someone. I've seen situations where because there's, if your estate goes beyond a certain value, that's going to trigger you owing estate taxes to either the state or at a federal level. Being creative around actually essentially putting some financial burdens on farmland so that the valuation is actually lower. So maybe you add some type of contract provision to the farm. Maybe it's inside a trust and, there's some type of right of first refusal or other element that would then cause that property not be valued as high as just a pure acreage cost. So some techniques to lower the value of the farm estate to help with estate taxes. In terms of passing it on, there are some tax codes that have tried to help tackle this issue because there's plenty of examples of, the farming parents pass away, the kids are trying to pass it on, but because of the value of the estate, they have to sell off the farm to pay for the taxes on the farm. Those rules are very specific and you have to meet very specific requirements to get a special valuation in that case. But I guess to summarize, yes, there are techniques that could go into farm planning. Again, that would require some specific, conversations around that person's case and what they're trying to achieve.
So I'm going to invite anyone who has additional questions to go ahead and unmute themselves and jump into the conversation of what can we answer from today's webinar. Seeing a lot of continued mutes. Or if you're more comfortable typing the answer using the
you
chat.
can also, if you want to type in chat.
An old trick I've learned is you ask a question, count to 10. It's uncomfortable, but giving you a chance to really think about it. All right, barring any technical difficulties, I think we don't have questions, which is a-okay, fine. We would really like to invite anyone with questions that just wants a more personal or individual take on this. Matt and I are both very happy to talk with you about your situation. Like we said at the beginning, we're not attorneys. However, we do deal with a lot of estate planning aspects as financial advisors and planners. And so we can point you in the right direction, potentially provide some more feedback on your personal situation. We do help people using our estate planning partner, and we've done that for many clients, helping them build out an estate plan. If you're in the I need some help stage and you're not DIY and you're not fully needing an attorney, it's kind of a nice middle ground. So we're very happy to help anyone who has those questions. We did create a survey, which if Matt, you can try to pop the URL link into the chat, that might be easier. If you happen to have a smartphone that reads QR codes, this will take you right there. Just a quick 3-minute question survey, just to provide us a little bit of information on, did this feel educational, provide value, any of those things. We want to make sure that we're always seeking to inform our clients, educate them, keep them up to speed on what they need to be able to accomplish within their plan. So use that QR code if you can. And our hope is to create more webinars like this. Matt and I had hosted a podcast for about 20 or some episodes, found that we weren't reaching people in quite the same way that we were hoping to. So this is our plan B so far, and to hopefully create maybe once a quarter if that time allows. It might be twice a year. But if you have a topic you'd like to hear more about, we are more than happy to put together a presentation and offer that up to clients, friends, family. We're happy to help. And so this was recorded today. We will be able to send out a link following a little later today. So if you would like the recording to revisit anything, send on to anyone, let us know. We'll be happy to shoot it to you. If you'd like any other resources, have questions, you know who we are, and you can reach us at 309-691-9600 or by our emails, which hopefully you have, but matt.rupert, RUPERT @palomarwealth.com or kelly.holloway @palomarwealth.com. Kelly with a Y. So, Matt, you want to close this out?
Sure. On the disclosures.
Oh, yeah, this is the fun screen. Please feel free to read this.
Yeah. The normal disclosures of any presentation. So that will conclude the webinar. So securing our financial future, talking about estate planning. Thank you for joining us. You've got the survey link in the chat, or if you were able to do it with that code. I did get one response, responded back to them. Did get one question here. We'll try to address that. Guarding investments, planning via a will to go to children if you were placed in a nursing home. Yeah, I think that somewhat gets to Kelly's conversation about the Medicaid planning, the spin down provisions. There are specific rules on if you basically deplete all of your assets, what are the, there's an income test and an asset test that has to be met for you to be eligible for Medicaid. I have seen situations where people are trying to get a house outside of a person's name to try to hope that wouldn't get clawed back by Medicaid. But there are some rules around that. There's a look back test. So if you try to do that right before they were going to go into a care facility, Medicaid still could come back and say, well, no, you were intentionally doing that to avoid spending your own assets for medical care. But I would say if you'd like to have a conversation specifically on that, definitely reach out. I'm not going to guarantee that we can, give all the answers, but we do have some resources of attorneys that we have reference to people to as well. So if it is a very detailed case, we can provide that resource as well to say, hey, maybe it'd be worth talking to this group or this person for some specific recommendations. I think that's that one, and I appreciate those that are saying thank you in the chat. We're excited to see the registration and the turnout that we got on this webinar, and like Kelly said, hope to do more of these and provide as much education as we can. So thank you, everyone.